I mean, a lot of claims. A lot of claims in two areas, I think, actually, because tribunal claims are the obvious one, where people will feel unjust that they've been made redundant with their colleagues. Certainly those employees that are pooled together, where you've got a group of 10 employees, 5 will be made redundant. So there will be those situations where the aggrieved 5 employees who have been made redundant may feel as though, actually, why have I been made redundant? Why am I the one who's been selected? And so unless the employer has got an objective criteria that you can justify, then in those circumstances there could be a claim. But the other type of claims that we see, that we've been approached about, are where groups of employees are being made redundant, and they're wanting to set up in a competition with their employer. And there's a different element to it, because they say, actually, what we're going to do is look to try and misuse or take our employer's client list or confidential information and look to use that. So I think what you'll see are small startup businesses and claims being actually pursued by the former employer against the employees for enforcement of breach of restrictive covenants or misuse of confidential information. So I think that's a different element to that that you've got. And certainly the policy that you guys have cover both. So the policy that ARAG have will cover claims being pursued by employment by former employees, but also it will cover employers to pursue former employees if there's a breach of a restricted covenant. So if they're selling in competition or going working for a competitor and trying to, steal clients or misuse sales data or confidential information.